everyone, I'm Nazarat Fatima. Welcome to LiveLaw. It was held in a significant judgment by the Punjab and Haryana High Court that after the investigation is concluded and the charge sheet is filed, the accused shall be released in case decision of prosecution sanction is yet to be taken or communicated as per the Unlawful Activities Prevention, Recommendation and Sanction of Prosecution Rules 2008. A division bench of Justice Harinder Singh Sidhu and Justice Lalit Batra observed that the provisions of UAPA are stringent, and keeping in mind that a specific time limit for grant of sanction has been fixed, it would be a travesty of justice if the accused is kept in custody for long periods after conclusion of investigation just to await sanction so that cognizance may be taken. As no consequence for the delay in grant of sanction has been stipulated in the UAPA or rules, in our view, it would be appropriate that in such a case, the accused is released on interim bail to surrender once the sanction is received. The court also said that when the accused is granted interim bail, he shall give an undertaking that he will surrender before the court as and when the sanction is granted. And after he surrenders, he can avail of his remedies, including to apply for bail. The Kerala High Court had also put forth similar views and had said that the time frame for grant of sanction prescribed in UAPA rules is mandatory. Now the question is, if cognizance is taken on a sanction order granted after the prescribed period, whether the same would be vitiated. The division bench did not express any opinion on the question. In relation to this issue, the bench said that this particular issue is not in question and there is no occasion to consider it. Another case that the court relied upon was Vijay Rajmohan versus CBI. In this case, the question on grant of sanction had arisen in the context of the Prevention of Corruption Act. Coming to some details of the case in present. It was an appeal against the rejection of default bail application by Additional Sessions Judge Jalandhar in a UAPA case. The accused had written Khalistan Zindabad with black paint on the wall outside the office of Gulshan Sharma. The appellant was charged under various provisions of the IPC and Section 13 of the Unlawful Activities Prevention Act 1967 and Section 3 of the PDPA 1985. The statutory period of 90 days for the presentation of charge sheet was to end on October 10, 2022, as no application for extension of time was moved. The police presented charge sheet against him on October 8 without obtaining any sanction from the competent authorities. The court noted that on October 6, 2022, an application for grant of sanction to prosecute the appellant was moved and the charge sheet against him was presented in the court on 8th of October 2022. While referring to the application seeking prosecution sanction, the court said that no decision has been taken on that and the period prescribed under the rules has long since expired. The court said that as per Rule 3, the authority shall under subsection 2 of Section 45 UAPA make its report containing the recommendation to the central government or the state government within 7 working days of the receipt of the evidence gathered by the investigating officer under the code. The court said, and I quote, "The central government or as the case may be the state government shall under subsection 2 of Section 45 of the Act take a decision regarding sanction for prosecution within 7 working days after receipt of the recommendation of the authority." Ultimately, the court granted interim bail to the accused. And said he would file an undertaking that he would surrender back if the sanction is granted. That's all about this issue for the day. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.